All right, let's get right into it. When you're stuck in a dispute, it can feel like you're staring up at a huge mountain, and the courthouse is way up at the peak. But what if I told you there's a powerful first step, a move that can define your entire case, and honestly, sometimes even solve the whole thing before it really begins? Today, we're breaking down the legal notice.
So, you've got a problem, right? Maybe somebody owes you money, a contract's been broken, or a service just wasn't delivered. Your mind probably jumps straight to lawyers and courtrooms, but hold on. There's a crucial strategic move you need to make first, and the answer is a clear, well-crafted legal notice.
But what even is this thing? Let's be clear, it's not just an angry letter you dash off. No, this is your first official, legally recognized move on the chessboard of a dispute.
At its heart, a legal notice is basically a formal heads up. It's you saying, hey, here is the problem, here's my complaint, and I am serious enough about this to take you to court. It puts the other person on formal notice that, the time for casual chats is over. The clock is officially ticking. And what's really cool is the triple duty this one document performs. First, it officially lets them know what's up. No more pretending they didn't get your calls. Second, it actually gives them an off-ramp, a chance to settle this thing before it gets messy. And third, and this is so important, it becomes your very first piece of evidence. This isn't just paper. It's proof for a judge that you tried to be reasonable before bringing them into it. Okay, so you get what it's for, but when do you actually send one? Well, the answer isn't always the same. It really breaks down into two key categories. As you can see, the situations really fall into two different camps. On one side, it's mandatory. The law literally requires you to send a notice in certain cases, like if you're suing the government or dealing with a bounced check. But on the other side, and this is where it applies to most of us, it's a strategic choice. For things like getting money back, a breach of contract, or property issues, you don't have to send one, but it is an incredibly smart opening move.
All right, let's get practical. I want you to think of a legal notice like a blueprint for your case. If you get the structure right, you're building on a really solid foundation. So let's look at the essential blocks. Part 1 is all about the setup. It starts on an advocate's letterhead, which immediately signals you're serious. You need the dates, the recipient's full and correct details, seriously, no room for error here, and a subject line that is crystal clear. Nobody should have any doubt what this letter is about from the second they lay eyes on it. Next up is the story. Now, this isn't a novel, it's a precise step-by-step account of the facts. You state who you are, what happened, when it happened, and which agreement was broken. This all leads to something called the cause of action, which is just a legal way of saying, here's the specific right that was violated. And the final act? It's the demand. After you've told the story, you state exactly what you want. And be specific. You want a payment, an apology, a certain action. Then you set a firm deadline, usually about 15 to 30 days. And finally, you lay out the consequences. If you don't comply, a lawsuit is coming. An advocate's signature seals the deal. But look, just having the right parts isn't enough. The way you write the notice can be the difference between it being taken seriously and it ending up in the trash. This is where the art of persuasion comes in. Think of this table as your guide. On the do side, be precise, be formal, and be 100% factually accurate. And on the don't side, avoid being vague, and please absolutely do not use emotional or threatening language. Any insults or exaggerations will only come back to bite you later. Just stick to the facts. Trust me, a professional tone carries way more weight than an angry one. So, you've drafted the perfect persuasive notice. Awesome. But your job isn't done yet. How you actually send it, and how you react if you get one, is just as important as the words on the page. This isn't like sending a birthday card. It's about creating an undeniable paper trail. You have to use a method like registered post with acknowledgement due, often just called RPAD. This gives you legal proof that the notice was sent and, more importantly, that it was received. Keep a copy of everything: the notice, the postal receipt, the tracking info. This is your evidence. Now, for a second, let's flip the script. What happens if a notice like this lands on your doorstep? You have a few options, but there is one thing you must never, ever, ever do. Ignore it. Ignoring a notice is a massive mistake. As this timeline shows, right from day one, you lose your best chance to negotiate a settlement. By day 30, a case could be filed against you. And if you do end up in court, a judge is not going to look kindly on the fact that you just blew off a formal attempt to sort things out. Your silence speaks volumes, and not in a good way. So as we wrap this up, I want you to remember the main idea here.
A legal notice isn't just some angry threat. It's a powerful, strategic tool.
And that is the bottom line. The quality of your notice sends a huge signal. A vague, emotional, or poorly written notice basically screams, I don't have a strong case. But a clear, factual, professional one, that can force a negotiation and get you a settlement, potentially saving you a ton of time and money.
This quote really just says it all, doesn't it? It's not about ticking a box. It's about taking control, framing the story of your case, and setting the tone for everything that might come next. At the end of the day, every dispute is a story that's waiting to be told. The legal notice is your chance to write that first, all-important chapter on your own terms. So the real question is, how are you going to write it?